So, what happened in Blimpy? Which I didn't know still existed until I flew through the Omaha airport. It's like, yeah, there's a Blimpy there. And I went to Taco Bell. But anyway, OTR owns a shopping mall and leased space to a company called IBC Services. So here's our lease agreement. IBC Services is owned entirely by Blimpy. It's a wholly owned subsidiary. And what IBC Services does is it gets these leases and it subleases them to franchisees. And so in this case, the franchisee was another corporation called Smyrna Inc., which was owned by Sam and his wife, Ishkander. So IBC had one purpose and one purpose in life. Its job was to hold leases, to get leases on behalf of franchisees and then sublease to them. That's all it did. And it didn't have any business premises of its own. It didn't have any assets. It didn't have any employees. It didn't have any staff. It didn't have any income other than the rent payments from the franchisees, which were made directly to OTR. Pass through. Money going in, money going out. It has $0, 0 office, 0 staff. What is the purpose? Liability shield. Right? What does Blimpy want? They want to be able to give their franchisees good lease deals and not be stuck holding the bag. That's a great scheme, except it's illegal and it's violation of corporate law and it won't work. But it's a good thought, Blimpy. Good try. Right? So what does that look like here? First off, why would IBC Services get a better lease than Smyrna? Okay, who here has heard of Smyrna Inc.? Who here has heard of Blimpy? Okay, still not that many. But more. Right? They've got T-shirts, they used to have, I think, national ad campaigns. And so they walk in the door, and not only that, but IBC Services walks in the door wearing Blimpy shirts. Can you picture it's green, like kind of a yellow logo, like circular, kind of roughly sub-shaped, kind of reminiscent of like lettuce and a bun. And so they're wearing these Blimpy shirts, looking like they're purveyors of submarine sandwiches. And they walk into OTR's office, and they lead them to believe that they're acting on behalf of Blimpy, that they're from Blimpy Corporate, and in fact they were. Remember, IBC Services had no employees of their own. So these guys actually were on the Blimpy payroll. They were wearing their Blimpy shirts. They were receiving their Blimpy 401k. So, what result here? Do we pierce? Yes, finally we pierce. We have enough facts. We have something much more. The plaintiff is not as sympathetic. It's just a shopping mall. But the use of the corporation here was a scheme, a scam, a fraud. And there was misrepresentation. So let's go through the factors here. First off, ownership and control. Was IBC Services effectively the alter ego of Blimpy? Yes, it was. It had none of its own employees, none of its own offices, none of its own finances, right? None of its own T-shirts. They wore the Blimpy T-shirts, for crying out loud, right? But control alone is not enough. That's the first of the 3 factors. What are the other 2? 2, they used this to commit a fraud or injustice, some improper purpose. Well, did that happen here? Yeah. OTR testified they thought they were dealing with Blimpy directly. And IBC never expressly stated that, but it led OTR to believe it was Blimpy. For example, as I mentioned, the people who went to make the inquiry were wearing, both Blimpy uniforms. I guess they were wearing the Blimpy shirt and the Blimpy hat, right? Maybe they had Blimpy shoes on, had little sub-shaped shoes. In addition, the lease stated that IBC's address was the same address as International Blimpy Company. All of this would lead a reasonable person to believe they're dealing with the International Blimpy Company. Now, yeah, I'll give you guys a lease. You make subs. And you have assets. And you have franchisees. Right? You're a safe bet. Probably give them a lease at a better rate. You're always going to give someone who's less risky a better rate than someone who's more risky. There's just a price of that risk. Right? We've never heard of Smyrna, however you pronounce it, so we're going to give them a crappy rate because they may not pay. And they didn't. We're going to give Blimpy a better rate because we feel more sure that they pay and that we have some recourse. So Blimpy comes up with this great idea. Well, let's have our cake and eat it too. Right? Let's set up this subsidiary which will block our liability while at the same time pretending that they have assets, pretending that they're us. Yeah, that's not going to work. The court rejected Blimpy's argument that it observed all the corporate formalities and so it should be entitled to the benefits. Right? That's our last factor. They didn't fail to follow corporate formalities. They did misrepresent. They did commingle assets. They were undercapitalized, but they documented it. Yeah, that's not enough. That's not enough. Misrepresentation alone would probably be enough. The court said the separate corporate shell created by Blimpy to avoid liability may have been mechanically impeccable. But in every functional and operational sense, the subsidiary had no separate identity. It was, moreover, not intended to shield the parent from responsibility for its subsidiary's obligation, but to shield the parent from its own obligations. Right? It was not intended to shield the parent from its subsidiary's obligations. That's normal. It was intended to shield the parent from its own obligations. It wanted to give its franchisees cheap leases, and it did not want to guarantee them. Not okay. That is an evasion and an improper purpose, fraudulently conceived and executed. And so here, again, like C3, we have clear-cut case for Pearson. So can you distinguish the cases? Yeah. On the one hand, a concierge at the Westin Regina gives some really crap advice to go snorkel in a deadly area. And someone dies, which is terrible. And the recourse goes to the Westin. Do we then bring Westin Mexico and Westin International into that story? No. No, this was a typical parent-subsidiary relationship. And unless the Westin Mexico is siphoning away the Regina's assets or maintaining similar properties or otherwise misrepresenting that they're one and the same when they're not. On the other hand, an OTR associates a shopping mall leased space to a Blimpy subsidiary who then subleased it to a franchisee who then failed to pay the lease. And by the way, a sublease means that the original lessor is still on the hook. You know there's a difference between a sublease and an assignment, right? In an assignment, the liability is cut off. But in a sublease, both parties remain liable. Both the original lessor and the sublessor are joint and severally liable for paying on the lease. And so I assume that OTR was not comfortable with the ability to assign the lease. They probably said, no, we want Blimpy to pay the bill if these franchisees don't. This was evasion fraudulently carried out. Is the difference between contracts and torts? This is a contract, this is a tort. Is that the difference? No, probably not. We have way more factors than that here. So I do put contract and tort piercing is something to think about. That balance has changed somewhat over time. Now it's not even entirely clear that the piercing is that out of balance. What we're really looking for is misrepresentation first. Well, first and foremost, we're looking at if the corporation is closely held or solely held. If the corporation is widely held, we're simply not going to find the kind of domination and control. I mean, think about it this way. Even if this number of people, everyone in this classroom, 20-some of you, right, got together and formed a corporation, would you always be able to agree on it completely in a way that your collective ideas would dominate and control it? No. I mean, there's not going to be a situation where 20 people always agree on anything. How about 1 million shareholders? It's never going to happen. You're not going to have that alter ego. I mean, there is no, well, there's several egos here probably, mine most of all, but there's separate egos. There's not one, class ego here that could control. So likewise with a widely held corporation. The second is going to be whether or not there was misrepresentation, because courts are really going to get you if you've committed fraud, and that comes out in OTR Associates and in C3. Next, we're going to look at whether there is going to be some type of commingling of assets where you're treating the corporation, you're disrespecting the corporation's separate identity and treating it like it's not one. Why should you get the benefit of treating the corporation like your own piggy bank and others have to respect its separate liability? Right. Similarly, not as bad, but similarly, if you're draining money from the company on purpose, knowing that it won't be able to pay its debts so that you can enrich your pockets, well, that's very similar to commingling assets, and it's going to get you pierced. And then finally, failing to follow formalities. But remember, why does failing to follow formalities rarely itself cause piercing? What are the three elements of the alter ego doctrine? So let's say that there is a failure to follow formalities. How would that failure to formalities cause harm? Remember, the second element, right? The particular action, the wrong action, has to actually cause harm. Has to be the proximate cause of some actual harm. It's not as likely that simply failing to follow corporate formalities itself is going to cause the type of harm that will lead to piercing. Okay, so you didn't have a meeting, you didn't have quorum at the meeting, or the meeting wasn't documented properly. Sure. But what was really going on? Was it a misrepresentation? Why does this party harm? Why is this party unable to collect under the contract? So it's probably not going to be enough. Deception by inciters is much more decisive. And the other factor which sort of goes on to here is, I think, as we saw in Darbro, did the other party have a way to protect itself? We're going to be less likely to pierce when the plaintiff is sophisticated and had some other way of protecting themselves. So in the case of Darbro, what did that look like? It looked like a really sophisticated seller who didn't get personal guarantees. They had that option. Other investors got personal guarantees. They didn't negotiate for it. Maybe they would have got a lower sale value with personal guarantees. Maybe they had to sell to somebody else. Maybe they have to hold the property a little longer. But they knew what they were doing, and they didn't do it. Any questions on piercing the corporate veil? So this is a very frequently tested topic, and you should be prepared to address it on the bar exam, and for that matter on my exam. So key takeaways here, right? The first element of the alter ego doctrine relates back to the factors. So whether or not we have domination and control, that first aspect here has to do with whether or not the governance structure would permit it. Right? On the one hand, a sole shareholder could very well dominate and control a company. 1 million shareholders in Microsoft, not going to dominate and control. And then we need to find some harm. Right? Whether that harm is caused by misrepresentation, commingling of assets, undercapitalization, those are all things that can result in harm to a tort or a contract party. Because there's not money to pay for the tort claim, not money to pay under the contract. We have to have that harm, and that harm has to be caused by the domination and control. So it's a three-factor test. We haven't seen a case where we've pierced for enterprise liability, cross, and what you can take away from that is it is even less common, because under what circumstance would one entity control the other? Right, so we didn't see that case. We saw cases where that wasn't going to happen, right, in the case of Carlton. I don't think I have really much else on this. Yeah, any questions then? Yeah.
For enterprise liability, are the factors still the same as far as control and things like that?
Yes. Yeah, it's just a question of the direction. I have a couple. The enterprise liability doctrine is not going to come up as often, but let me flip to a couple notes on that here. So the court in Walkowski made the following statement. It is one thing to assert that a corporation is a fragment of a larger corporate combine which actually conducts the business. Effectively, what that's saying is that you may have five subsidiaries, but because they're all dominated by the parent, they're all liable. We'll pierce through all of them because really this is one thing. But we need to find that we still need to find there was some domination and control. What we find here is there's domination and control of S1 and, let's say, and the other entities. So it's actually harder to prove. It begins with really finding that there was some alter ego. And in fact, all of these were effectively one ego, if you will, that there is some larger corporate combine. We didn't see that case presented here. It's much less common.
Control of the parent company, it's not control of like subsidiary.
So if a subsidiary could theoretically control another, and that would create enterprise liability. So sorry, I didn't get your right. But there could be some control here. I mean, usually that would happen through the parent, right? Who's going to siphon money from S1 to S2 or something like that. But we do see structures that, I mean, this is assuming that this is like a real structure. We also saw C3 computing, where there was some weird contractual relationship where an independent contractor was really the de facto owner of an entire corporate entity. And so it's possible that S2 is really the de facto owner. And we'd have to get to that, though, with some kind of equitable ownership. And so we don't see that here. Enterprise liability against corporations would expand the assets, but only when those corporations are operated as a single economic unit, right? And so we're looking for really that alter ego writ large. I suppose, like you said, it's possible that these are all operated as a single unit, and so we'll disregard the shield between them. But that means that there is some puppet master controlling all those strings. Other questions? So you should be prepared to go, really at the end of the day, it's a three-factor test, right? The alter ego doctrine is a three-factor test for piercing up to the parent. And it really focuses primarily on 4 factors to the first one. So under the first factor of the three-factor test, we have 4 plus factors. We have, well, again, like I keep not even calling it a factor because it's so vital to have some type of very closely held company, either solely held or 1 or 2 or maybe 3 shareholders. By the time you get to 4 or 5 shareholders, the percentage of piercing drops to single digits. And so that's almost like a limiting factor. But then we look for misrepresentation, we look for commingling assets, undercapitalization, which is like commingling assets, but not quite as egregious, right? Sort of taking assets legally and with procedure, and then failing to follow procedure. But note that you don't have to meet all 4. In fact, we have at least one case where formalities were followed and piercing happened anyway. Let's go back to make sure there's nothing else. We talked about comparing this to other creditor protections, and so one of the reasons that we do pierce is when there are no alternatives to protection. And so we're going to be more likely to pierce as well where we do not have the ability to make personal guarantees or where someone's not as sophisticated, where there's a power asymmetry, a bargaining asymmetry. So this is a multi-factor test, and you could feel free to look at all the facts and circumstances. Remember that it's an equitable doctrine, not a legal doctrine. So courts apply equitable doctrines more flexibly when justice so requires. So absolutely deal with the factors presented, but especially on the bar exam where examiners like to throw you more curveballs, you definitely want to look at what are some other plus factors you can mention, right? Is someone at an unfair advantage in the contracting process, right? And you might bring up that at least theoretically, it doesn't seem to bear out, but at least theoretically, involuntary claimants, tort claimants, should have a little more access for piercing because they are not able to bargain and to protect themselves against the corporate form. The problem with that is that the number one factor is misrepresentation, and there's no way to misrepresent a tort. Right? As I said, like no one's saying, I promise to run you over with a cement truck, and you really only hit them with the Toyota Camry. And that's not how torts work. Torts are involuntary, and so there's not a misrepresentation ahead of time that leads to the harm. The harm is the result of being unable to pay for the tort that was committed. Any other questions? All right, so that's it for today.